Today we're pleased to make Judge Herbert E. Phipps, the Chief Judge of the Georgia Court of Appeals, a member of this graduating class by awarding him an honorary Doctor of Laws degree. He has been a great friend of John Marshall and a source of personal encouragement to me during my 8 years here in Atlanta. To introduce Judge Phipps, we have asked Tommy Malone. He would be surprised to see his full legal name in the booklet since nobody calls him that. But Tommy is a giant among American trial lawyers. He means a lot to John Marshall Law School as well. He's the father, one of our most outstanding graduates, Adam Malone. And he's someone who knows what Judge Phipps has accomplished better than almost anyone. So we're proud to have Tommy here to introduce Judge Phipps. Tommy?
Thank you very much, Dean Lynn. Graduates, friends, family, distinguished members of the panel, be true to the calling to which you have been called. Be true to the calling to which you have been called, and understand there's no greater work in life than making a meaningful difference in the lives of others. No one I know stands for those two principles any better than our commencement speaker today, Herb Phipps. Now let me take first things first with regard to his many, many accomplishments. He was able to persuade Connie Curry to marry him several years ago, and they have a son, a daughter, and now a granddaughter. So congratulations, Judge Phipps. You did very, very well, as did I finally. You were luckier sooner than I was. But I want to tell you that he's been past president of the Daugherty Circuit Bar Association down in Albany, been past president of the Atlanta Lawyers Club. His charitable and civic awards are numerous, but he's special. I mean, everybody's got all those things they can say about him if they've reached the heights that Judge Phipps has reached. They have to serve others. They have to serve the profession. But I want to tell you from a personal standpoint, it is a special day for me. You just don't know, I almost get tearful when I think about our both Judge Phipps and I, our roots are in Southwest Georgia. I graduated from Mercer Law School in 1966, believing in truth, justice, fairness, equal justice for all. And I returned to Albany, Georgia, where I began my practice in 1966, and boy, was I in for a rude awakening. The socioeconomic barriers, it wasn't just black and white. It was ordinary folks didn't have a chance in the courtroom against the rich and powerful and the controlling folks. My father was a prosecuting attorney in the state court, which he later became judge of at the time, and I was a great disappointment to him because I followed my heart. To his great embarrassment and my mother's embarrassment, suing doctors who I thought were wrong, suing the city and county, doing things like that. But this is not about me. But I have to give you a little bit of that background to let you know that Judge Phipps started off in Baker County. Baker County is just south of Daugherty County, a little more rural than Daugherty County. But any of you who think there are not two Georgias have simply not been to both of them. They're as different as night and day. And I am so proud that I started in Southwest Georgia and that our paths crossed down there. But they left Baker County, I think, because they didn't have the ability to graduate from high school, and your parents brought you to Daugherty County, where you graduated from high school. Then he went on to graduate from Morehouse. And it's worth saying now that the thing that makes a difference is clearly education to me. Education makes a difference, and that's what's so important to y'all. But he went on to Morehouse and graduated, then went to Case Western Reserve, where he was editor of the Law Review, and he came back to Albany, Georgia in 1971. I had been practicing since '66, and I didn't know how much our lives would make a difference in justice for the people of that community. And I have to tell you this, I got a call from my father, who by now was judge, and that was probably in about 1974. And my father said, "Tommy, somebody called me and told me that they saw you down south of Oglethorpe going into C.B. King's office." He was the only African-American lawyer when I got to Albany to practice, and there was only one lady lawyer. Times have changed, haven't they? He said, "You ain't supposed to go down there. He's supposed to come up to your office." And I said, "Well, Daddy, I've been trying to persuade CB since we got black jurors and white jurors now that he and I together would be better before the juries than either one of us apart. Well, you ought to get him up to your office. You don't go down there." And somebody had seen me do such a thing and called my father to tell on me. That's the society at the time. So anyway, I said, "Well, Daddy, I know I've been disappointing you ever since I started practicing law, if not long before. And I'm just going to disappoint you again because I'm going to still go down there and see CB." Well, he accepted me. And I continued on fighting these losing battles. The Civil Rights Act of 1964 found its way to Dougherty County a few years after Judge Phipps started practicing down there, probably about 1974, and you started seeing representative members of the community on the jury. Well, anyway, you can read the details about Judge Phipps and all his accomplishments in the brochure that you've got or online or something. But I want to tell you that I talked to that same judge, my daddy, and I said, "Daddy, why don't you appoint Herb Phipps, this bright young lawyer that's working with C.B. King, to be an associate judge of your court?" He said, "What?" And after a little while, I convinced him. I won't go into all the leverage I used to convince him, but I convinced him it would be a good thing, particularly since he ran for public office. And he served as judge until '86. And he agreed, and I think I was the one that was permitted to tell Herb he was going to be offered the appointment. And he was so proud that he could, because he knew what significance that was to the people of South Georgia, to people everywhere. And I said to him, "Herb, you know, you can be on the highest courts of Georgia one day if you want to." And that was back in about 1974, 75. And I am so proud to introduce to you my friend, Chief Judge of the Court of Appeals, the Honorable Herbert E. Phipps.
Thank you, Tommy, for that introduction. I'll always be grateful for what you convinced your father to do so many years ago. It has made a great difference for me, a great difference for the people of Dougherty County and Southwest Georgia, and I think even touched the people of the entire state of Georgia. Members of the class of 2014, congratulations to you and to your families. Because I know that you are eager to have this ceremony in and receive your degrees, I won't tell you any of the very funny jokes that I would like to tell you. Dean Lynn, thanks to you again for all that you have done for John Marshall Law School. Thanks also to the Board of Directors, faculty, and administration of this school. I am honored to be awarded the Honorary Doctor of Laws degree and to have been invited to deliver this commencement address. Class of 2014, I have chosen to address you on the subject, Courage at the Bar and on the Bench. Courage at the bar and on the bench. I chose this subject because I hope that courage will be among the traits that distinguish you in the profession. Lawyers should be honest and competent, and most lawyers are honest and competent. Nevertheless, When people engage the services of lawyers, I think that they want lawyers who also possess a third characteristic: courage. Speaking at the University of San Francisco Law School in 1962, Attorney General Robert F. Kennedy said, "Courage is the most important attribute of a lawyer. It should pervade the heart, the halls of justice, and the chambers of the mind." With some background on my early years and the environment in which I entered the practice of law, I think that you will understand why I believe courage is essential in lawyers and judges. As you've heard, I was born in Baker County, deep in southwest Georgia. I spent my early years on a farm owned by my paternal great-grandfather. Baker County at this time was so rigidly segregated that I was about the 5th grade before I discovered that white children also went to school. Black citizens were victims of widespread violence and intimidation, and Baker County could have been the poster child for racial injustice in America. The surrounding counties were not much, if any, better. You may have studied the case of Screws versus the United States. The opening line of that opinion is unforgettable. It reads, "This case involves a shocking and revolting episode in law enforcement." That shocking and revolting episode in law enforcement occurred in Baker County when I was a child. The case involved the lynching of Robert Hall, a black man, by Baker County Sheriff Claude Screws and other law enforcement officers. There was evidence that Screws forged a warrant for Hall's arrest after the lynching, a spurious afterthought. Not surprisingly, as was customary in those days, there was not even a thought of a state prosecution for that lynching. There was a federal prosecution on misdemeanor charges. Ultimately, Screws and his helpers were acquitted by an all-white jury. Even in the federal courts, blacks were not fairly represented on the jury list. During that time, racially motivated violence and mistreatment was made worse for black people because they had nowhere to turn for protection and relief. Certainly they could not turn to law enforcement and not even to the courts. Those with authority to provide protection and relief were part of the problem. Experience had taught black citizens that they could not expect justice from state and local authorities. But to their dismay, the United States government stood by and watched this violence and intimidation and abuse with indifference and inaction. When I was about 10 years old, I witnessed a Screws deputy, Gator Johnson, threaten to shoot my father in the yard of our home. And this kind of gratuitous, hostile encounter was common in the black community. Perhaps there were some white people in Baker County who did not approve of these abusive practices. But if that were the case, no one knew it because they did nothing to stop it and did not even speak out against it. As a child working on the farm, stooping and bending and lifting, sometimes I would complain that my back hurts. The adults would always respond, "Boy, you don't even have a backbone yet. You still have gristle. Now get back to work." A strong backbone is a valuable asset for a farm worker. Backbone is essential for lawyers too. In lawyers, it's called courage. In high school, I began to visit the segregated courtrooms of Southwest Georgia to watch trials. Time will not permit me to tell you about the hostile encounters that I had with sheriff's deputies and U.S. Marshals who tried to keep me out of the state and federal courtrooms. What I saw in those courtrooms is what caused me to become concerned about courage in lawyers and judges. I saw lawyers and judges and law enforcement officers routinely insult and mistreat black people in the courtroom. Except for C.B. King, the only black lawyer in South Georgia at that time, I never saw a lawyer or judge object to the mistreatment. Nonetheless, even C.B. King, the lawyer, was not exempt from insults and abuse. One afternoon, I saw him with his head bandaged and his shirt bloody. He had been beaten with a cane by the Dougherty County Sheriff. He was beaten when he went to the jail and demanded to see a white client who had been beaten unconscious by his white cellmates. They beat him after they were told that he was a civil rights worker. I don't think I have to tell you that there were no prosecutions for any of this. And on another occasion, I saw C.B. King when I was in jail. I was working in voter registration with the Student Nonviolent Coordinating Committee. And the police would often do things to intimidate and arrest us. And one night, I was in a telephone booth using the phone, and they came by, saw me because the light was on and they could see, and they arrested me and took me to jail. And I was never booked, never charged. This was Tuesday night, and I was held to the noon on the following Monday. But while I was in jail, Martin Luther King was arrested, and he was put in a cell right next to the cell that I was in. And C.B. King represented him in Albany and came down to see him. And that's when he saw me in jail, and I asked him to make sure that my parents knew where I was, because the folks at the jail, I learned later, had denied that I was there. And one thing I'll always remember about that experience, being in a cell next to Martin Luther King, one day they allowed the folks to bring him some food from the outside. And I never will forget that he passed me a drumstick around through the bars. That was the best piece of chicken I have ever had. But watching what I saw in the courtrooms and in the community, I could see that C.B. King needed help. He couldn't represent everybody who needed protection from discrimination and abuse. I could see also that the law was sort of like a hammer, a tool that could be used to protect people or to abuse them. And in the spirit of the lyrics of that popular song, I began to wonder what could happen if I had a hammer. And I resolved to get one in the form of a legal education. Meanwhile, I saw a district attorney prosecute dozens of people for peacefully protesting segregation. He knew that the charges were not supported by law or evidence, and after the hearing, the judge instructed the lawyers to come to his chambers. I was not a lawyer, but I followed them into the privacy of the judge's chambers, away from the crowded courtroom. The judge told the lawyers that the evidence was not sufficient and that the charges should be dismissed. Then he said something that I remember as if it were yesterday. He told them that he would not dismiss the charges and would not set bail because, he said, I have to live in this little town. Neither the prosecutor nor the judge had the courage to do what he knew was right. Being popular in that little town was more important to them than justice, no courage. Lawyers and judges should have the courage to do the right thing when the whole world is watching, and the character to do the right thing when no one is watching. Years later, I got what you now have, a legal education. And equipped with my hammer, I joined C.B. King in the struggle for equal rights for black citizens. When I entered the practice of law, the abuses, hostility, and indifference to civil rights that I had seen years before remained prevalent. I heard excuses like, I know it's wrong, but it's not my problem. Others will have to do something about it. I'm not going to take any personal or professional risks. Standing up for justice and equality for black citizens might hurt my reputation and cost me money and friends. Maybe later in life, when I'm financially secure, then I might stand up and speak out against an injustice. No courage. Then and now, such excuses are insufficient. Courage has never been risk-free, not in those times and not in these times. Private whispers of disapproval have never provided any relief to victims of injustice. These are different times. Conditions have changed, but we still have a lot of work to do. Our society will not, over time, self-correct any injustice that remains. History teaches us that time alone will not create a more just society. People must do it. People like you. No one with eyes and ears open to current events can honestly deny that there are still prejudicial attitudes and actions from which people need protection. As lawyers, you should, and I hope that you will, play an important role in making this a more just society. John Marshall Law School has prepared you for the job. Today, as you have heard, is the 60th anniversary of Brown versus the Board of Education, May 17, 1954. Also, we are celebrating the 50th anniversary of the Civil Rights Act of 1964 and approaching the 50th anniversary of the Voting Rights Act of 1965. Nevertheless, on this day, May 17, 2014, the problems that case and those acts were meant to remedy are still with us. Schools are still segregated. The right to vote is still suppressed, and other rights are still being denied. There is still a gap between the theory and the practice of equal justice in America. There are still forces among us that want to turn back the clock. People still need lawyers with the courage to protect their constitutional rights. Wherever and in whatever manner you use your legal education, often you will find that justice is being denied persons in your presence, in your community, and in your state. Do not look the other way. Use your power and influence to do the right thing and encourage others to do likewise. Seize the opportunities. Do not live your life in a bubble, unaffected by or indifferent to the injustices in society. In that 1962 speech, Robert Kennedy also said, lawyers have their duties as citizens, but they also have special duties as lawyers. Their obligations go far deeper than earning a living as specialists in some area of the law. They have a continuing responsibility to uphold the fundamental principles of justice from which the law cannot depart. Courageous lawyers and judges will anger and irritate people, but no one wants a timid lawyer or judge who is more concerned about his or her popularity than about justice. If you become unpopular because of your commitment to justice, wear it as a badge of honor. It is not essential for you to be popular in your little town if being popular means that you tolerate and participate in injustice. Years from now, I hope that each of you will be able to say that although you have done well financially, that was never your primary goal, that neither fame nor fortune is the accomplishment of which you are most proud. I hope that you will be most proud that throughout your career, you demonstrated a professional and personal commitment to truth and justice, that you were a lawyer with backbone, courage. There will always be a need for prosecutors with the courage to prosecute or not to prosecute based on the law and the sufficiency of the evidence, and not the social status, the cause, or other characteristics of the accused. There will always be a need for judges with the courage to follow the law and the evidence when confronted with controversial issues, without fear of this little town. There will always be a need for lawyers and judges with the courage to protect the rights of all, including renegades and social outcasts. There will always be a need for lawyers with the courage to tell their clients the unpleasant truth and encourage them to do what is right and legal, even at the risk of losing clients and money. There will always be a need for lawyers with the courage to tell any client and any lawyer in any matter, big or small, I am not going to do that. It's unethical. There will always be a need for lawyers with the courage to represent ordinary men and women against the rich and powerful, including governmental entities and large corporations. Courage is an indispensable attribute of a lawyer. I caution you to be on good behavior. I was inoculated with that principle very early in my career. As we went about our work, representing unpopular people and unpopular causes, C.B. King stressed the importance of high personal and professional standards. I can still hear him say, always be on your best personal and professional behavior, because we can't fight and beg at the same time. Living by that principle has kept me out of the ditch and on the path that brought me here today. I commend it to you. If you are compromised by substandard personal or professional conduct, you will not be able to fight for justice for anyone, Excellence alone is not enough. High achievement without high character is a prescription for trouble. High character is a shield for courage. In closing, I share with you some of what Morehouse College President Dr. Benjamin E. Mays said to my class at our graduation 50 years ago this June. In the years to come, you will make my spirit glad. If you are known in life by the quality of your work and the integrity of your character rather than the quantity of your possessions. I do not know what happiness is, and I do not think it is important that you be happy. But it is important that you find your work and do it as if you were sent into the world at this precise moment in history to do your job. If happiness can be achieved, it will be found in a job well done and in giving and not in receiving. May the years ahead be motivating, challenging, and inspiring years. And may they be gracious and kind to you and bring you success in all the good things that you do. Members of the class of 2014, good luck. We are counting on you. Thank you.
Thank you, Judge Phipps. What a great speech and so many important things that you've just told us. Mrs. Phipps, would you rise so we could also thank you for all that you've done to support Judge Phipps over the years? Thank you, too. To confer the honorary degree, I'll ask the chair of our Board of Directors, Atlanta lawyer Richard B. Herzog, Jr., to come to the podium.
Thank you, Dean, and thank you, Judge Phipps, for your inspiring and powerful address. It reminds us particularly of the importance of courage in the practice of law and courage in living our lives. It also demonstrates the reasons why we at John Marshall would like to honor you by vesting this honorary degree upon you. And now, by the power vested in me by the Board of Directors of John Marshall School of Law, I hereby confer on you the degree of Doctor of Laws, honoris causa. Doctor. Thank you very much. Put this around the neck. The diploma's down there. Good. Well done. There's a photographer out of there. Well done.